Good afternoon, everyone. Welcome back. I'd like to introduce the next panel, our first panel of the conference, Ayahuasca and Freedom of Religion in Australia. And we're very lucky to have our panel facilitator, Dr. Amar Dhall here, who has spent about 8 years writing his PhD, which explored the nexus of quantum mechanics and law. During this time, he also learned about the ineffable nature of consciousness from traditional teachers in South America and Asia. Amar has organized his life around the intention to support the blossoming of human potential, which he does in several domains, including as a therapist coach, trainer, and facilitator. I'll pass over to Amar to introduce the panel members themselves.
So the three of us have written a chapter for a book called Religious Freedom and the Global Regulation of Ayahuasca. In this particular panel, we're going to talk about the way ayahuasca is regulated in various jurisdictions, and we're going to focus a little bit on a constitutional argument for freedom of religion around not really just ayahuasca, but the sacramental ingestion of entheogenic compounds. These sorts of arguments have worked in other countries, but we're going to map out what some of the problems are or what some of the roadblocks are to overcome in Australia. In terms of just introducing my fellow panel members, so Torsten here on my right, he's a consultant on legal issues relating to plant drugs and new psychoactive substances in Australia. His background in ethnopharmacology and decades of work in drug law reform provide a comprehensive insight into the Australian legal landscape on plant medicines. Torsten has organised ethnobotany conferences in Australia, owns Shaman Australis Botanicals, and runs the Corroboree, SAB, internet forums, as well as many other plant communities and research projects. On my left, we have Manny Satija. He's a human rights lawyer, mediator, coach, and psychotherapist. His work straddles the domains of social justice, cultural repair, and individual healing. He also integrates into its core systemic and integrative approaches to responsibility and well-being. Manny has worked closely with First Nations communities across Australia over many years and has been intimately involved in developing and implementing reparations and healing initiatives for stolen generation survivors. He has delivered numerous workshops relating to Australian drug policy and substance usage at music festivals and has published many writings relating to human rights, wild law, earth ethics, and the legal status of ayahuasca in Australia, including as it relates to freedom of religion-based arguments for sacramental usage of medicinal compounds. So with that said, I'm going to maybe introduce you, Torsten, to start to share what you know.
Okay, so when we're talking about ayahuasca legal issues, they have to be separated into two different aspects, which is the Hamalan component and the DMT component. So there's legislation at various levels, federal and state, that prohibit the import, the possession, the use, the sale of either one or the other or both. The legislation can be quite confusing, so some attempts at challenging these laws have actually been futile because they attacked it from the wrong angle. One of those was to try and get one of those compounds rescheduled by the TGA, but they didn't bother trying to reschedule the other compound. So that's it failed anyway. But sorry, I got lost in the notes there. So actually, can you just move to the next one? So I'm only talking about the state and federal legislation at the moment. Manny and Amar will cover the constitutional aspects because they're amazingly constitutional scholars. So this is quite a score that we managed to get them to an ETA conference for questions and for clarifying these issues that everybody keeps talking about. So the majority of health and drug laws are state-based, and so usually most drug reform needs to be done at the state level. States have the ultimate say over most drug issues. In the schedules, they're usually, like in the legislation, they're usually placed in the schedules. The schedules relate to the type of restrictions and the type of penalties that would apply. So, as I already said, that will cover customs, importation, possession, sale, any of those things. Next one, please. So while criminal charges are initially laid by police, the prosecutors have a huge range of ways of altering that. So one of the experiences I've had by talking to a lot of people who got charged with DMT offences or ayahuasca offences was that if there were any other drugs involved, usually the DMT charge gets dropped. Now that's no guarantee, so it doesn't mean that you can do whatever you want, and as long as you got some weed with you, you'll get off. But there have been at least 5 cases that I've followed in detail, where large quantities of DMT, like we're talking 200-300 grams, were dismissed. Like charges were dismissed as long as there was a guilty plea for the 5 ecstasy pills or the 10 grams of weed that were found at the same time. Because what usually happens when you get caught with one drug, they do a search, and usually they find other things. So, but again, this is why a lot of people say that, you'll never get done for ayahuasca, but you will actually. If there's nothing else, they will pursue that. They just like to take the path of least resistance. Once a charge is proven, the judge then has a lot of options. So a lot of people who say, I got off, what usually happens is no, they actually had to plead guilty or they were found guilty. But they got off on, in New South Wales we call it Section 10, which is extenuating circumstances. So if the defence lawyer can prove that that this is a one-off, that you haven't been engaging in it on a long-term commercial basis or something like that, then usually you get a slap on the wrist, and but you can only do that once every 5 years. So if you are a facilitator, for example, and you get busted, then the best thing is to not do it for at least 5 years. That covers that.
Thanks, Torsten. I might just quickly pick up on something Torsten was speaking about there in terms of criminal law sentencing. The temptation can often be to think of criminal law as this absolute thing where in TV they say this charge carries 10 years or this charge carries life, but as I'm sure everyone's aware, that's a maximum penalty which can be applied to a particular defendant facing a charge. And a particular area that can get sometimes confusing when we start off knowing that a defendant has been charged with a number of charges by police, and then when they have their day in court, whether they plead guilty and get sentenced, or whether they plead not guilty and have a hearing or a trial and found guilty, or the charges are proven and they're sentenced at that point. The sentencing process that the judge takes at that point compared to what the charges are can often create a bit of confusion in the community. And I guess what I want to underline here is by the time someone's charges have been proven guilty, the judge then has a complex process ahead of them of weighing up a number of subjective factors to determine an appropriate sentence. They'll look at the objective seriousness of the offence, prior offending history, personal circumstances, prospect of rehabilitation, whether there's a need for deterring the community from committing that type of offence. And then there's legal principles of totality, of when there's a number of charges and a defendant's been sentenced in relation to all of them together, to have one sentence which is sort of covers the whole course of conduct rather than separate little sentences for each charge. So really the point here is that what a defendant may end up being sentenced in relation to, as Torsten talked about, the Section 10 good behaviour order, isn't necessarily representative of how the justice system or police feel about a substance. There's too many other subjective factors in the sentencing process which impact that final outcome. So it's just something to be aware of as you hear further about drug laws. So I'm going to sort of change tack now and start talking about freedom of religion. And I'm going to start by talking about the international sources of freedom of religion under human rights legislation, and then I'll talk a bit about domestic human rights legislation before handing it over to Amar to speak about the Constitution. So Australia, as most of you may be aware, is signatory to a number of international legal treaties. One of the earliest treaties we've signed up to, which everyone is aware of, is the ICCPR, the Convention on Civil and Political Rights. And Article 18 of the ICCPR relates to freedom of religion. It's everyone shall have a right to freedom of thought, conscience and religion, and the right shall include the freedom to have or adopt a religion of belief, and to manifest the religion or belief in worship, observance, practice and teaching. I've highlighted, that part 1 of Article 18 is often what people pay attention to, that's the human right. I've highlighted subsection 3 just to tease out that this right is not absolute, and that's quite clear in the international legislation. 18 subsection 3 says the freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, and so on. So what that's saying there is this isn't an absolute right. Governments can restrict this right, but their restriction has to be reasonable. And so that's just something to bear in mind. This isn't an absolute right, even at the UN level. Now, a question may be, well, we've signed these treaties, we've signed ICCPR and a raft of other treaties. What impact does it actually have in Australia? And this is an area that can get a bit confusing, because on the one hand, we are part of the UN. You may see on the news Australian politicians are pushing to be the presidents of the Human Rights Council, and there's a lot of chatter that goes on every time they go to Geneva and New York. And it can be confusing to really understand, what does this mean at home? Can I claim that my human rights are being breached because we've signed up to a treaty? Can I claim that here in a court? The short answer is no, and I'll explain why. In Australia, our political system is such that treaties are signed by members of the executive arm of government, basically bureaucrats, whereas the power to make laws is held exclusively by politicians in Parliament. So what that means is when a member of DFAT, the Department of Foreign Affairs and Trade, goes to Geneva and ratifies a convention saying that Australia agrees to adhere to particular convention rights, that act of signing the treaty doesn't automatically mean it's binding in Australia. What needs to happen as the next stage is Parliament then needs to legislate domestic law to enshrine those rights in Australian law. And until that happens, we've signed a treaty and it's not really enforceable here. Two things to mention about that. A lot of the conventions have what are called complaints mechanisms, which are signed up to as part of optional protocols. So there is an optional protocol to the ICCPR, which Australia has signed up to, which means that individual citizens of Australia can claim a breach of Article 18 of ICCPR, saying that the Australian government has breached their freedom of religion. And the Human Rights Council, that's kind of a mock court, will listen to that case. But the thing that we need to remember is if the Human Rights Council finds against Australia, their only powers are to make recommendations to the Australian government about how to fix up their act. They can't actually compel them or force them to do anything because it's an international court, effectively. The other aspect which I wanted to tease out here is the question, you may be thinking, what's the purpose? Ultimately, if we sign this treaty saying that Australian citizens can enjoy freedom of religion and it's not enshrined in domestic law, what's the point? What can we actually do with it? The High Court provided in the case of Minister of Immigration, Ethnic Affairs versus Teo, which is a 1995 case. That was really where the legal principle came from around this. And And in effect, what it says is that when a member of the Australian government goes and signs a treaty, it creates a legitimate expectation that they'll make decisions in accordance with that treaty. Now, legitimate expectation is not the same as a legal enforceable right. So if a decision maker in a government department doesn't comply with the freedom of religion in the way they, for example, make some amendments to a drug act, it's not an enforceable right. That idea of a legitimate expectation has also been narrowed down significantly since 1995 to really limit its impact. And now it's what us lawyers call a procedural right rather than a substantive right, which means if I'm engaging with the head of a department that's making an administrative decision, and I believe that they haven't taken into account our human rights obligations, I've got a procedural right where I can ask them to take that into account, but I can't assert the right to try to overturn their decision, if that makes sense. It's a little bit complex, but it's an important distinction to kind of wrap your head around.
Can I just jump in and make a point here, Manny? Just the one point I want to raise here around legitimate expectation is generally ministers and other members of the executive are given a wide scope of discretion. So there's a lot of case law to show that even if there's an expectation, that just means that they can consider it, but they don't have to act on it. There's even been case law showing that politicians can make decisions around the likelihood of that impacting their electability, which can introduce an entirely different dynamic to the way a decision is formed. So just to really flesh out that in parallel to what Manny's saying, there's a bunch of other levers that are going to exert influence over the decision-making process.
Yeah, thanks, Amar. Administrative law in Australia is insanely complex. We're really just distilling a few key points relating to this topic, but as Amar says, there are a raft of other factors that go into it. So look, that's I suppose one of the key international sources of law relating to freedom of religion. I'm now going to talk about human rights legislation in Australia because we're in Victoria, and Victoria is one of 3 jurisdictions in Australia that now has human rights acts. So Victoria has the 2006 Charter of Rights and Responsibilities. ACT, where Amar and I are from, has the 2004 Human Rights Act, and the most recent is the Queensland Human Rights Act of 2019. All 3 of these pieces of legislation do include a freedom of religion, which is very similar to the way that it's set out in Section 18 of the international treaty that I spoke about, the ICCPR. For example, I've put up Section 14 of the Victorian Charter, which says every person has a right to freedom of thought, conscious religion and belief, including the freedom to have or adopt a religion, or the freedom to demonstrate his or her religion or belief in worship, observance, practice, and teaching. Now, these words, worship, practice, observance, that really starts coming into our consideration when we talk about, sacramental use of entheogens. Is that a religious observance? Is it a religious practice or a teaching? But there is a sort of, on paper, there's a broad protection for citizens of Victoria, the ACT and Queensland. So that's what's there in the domestic laws, and it's important to look at because more and more states and territories in Australia are either actively developing human rights legislation or they've started talking about it. So we're going to end up with a space where every state has a Human Rights Act, and then the question is, what does it actually mean? Can we enforce our rights under these acts?
Can I just jump in there?
Sure.
Another way to look at legislative reform is it's not uncommon for the Commonwealth to follow the states. So the idea being that the states and territories kind of iterate the thinking on an area, in this case human rights legislation, and then once that's been worked through, there's scope for the Commonwealth to evaluate all the data and then see if it's a suite of legislation that they could prepare. So I guess the point, all I'm landing is that there is some scope for change in the future. It's just we're partway through that process.
Thanks, Amar. So, continuing talking about these human rights acts, as I said, on the surface, it seems that they do provide quite a strong protection for citizens in relation to breaches of human rights. But unfortunately, the case in practice is a little bit different, because the way each of these instruments in Queensland, Victoria and the ACT have been drafted is not necessarily to create individual rights. It's more to, I suppose, ensure that new laws that are being drafted in these 3 states and existing laws that are already there are being interpreted in a manner that's consistent with human rights. So it's really about ensuring that public authorities, public departments, New South Wales, ACT, Queensland and Victorian government departments are exercising their functions in a human rights consistent way. But what that means is that there's not an individual complaints mechanism as yet where citizens in either of those 3 states, because they've got human rights legislation, can take a matter to the Supreme Court saying, my rights have been breached, I want remedy. What they can say in the ACT, for example, is they can, if they've already got a matter in court, it's another sort of loophole you have to get to. If you've already got a matter in court related to another piece of legislation, you can then ask the Supreme Court to have a look at the Human Rights Act to see if this piece of legislation is human rights consistent. You can't actually commence a new matter in court solely on the basis of an alleged breach of human rights. So that kind of limits what you can do with it. If you do make an argument, for example, there's a criminal matter in a Supreme Court of Victoria and you make a human rights argument, the Supreme Court will then look at that argument, will make a determination, but all they can do, if they find that that criminal law does breach of human rights, such as the freedom of religion, all they can do is issue what's called a declaration of incompatibility, saying this law needs to be looked at by Parliament, it's a bit incompatible right now. They can't, throw out the criminal charge, they can't provide compensation for any sort of civil law type wrong, so it is limited. And that declaration of incompatibility, the reason it's called a declaration is a particular type of legal instrument which is not legally binding. It's more a statement of intention. So,
Can I jump in?
Yep.
Yeah, so again, if we think of this in terms of, or the thinking behind it isn't to, just punish people or narrowly frame things, narrowly limit our access to recourse. It's more the case that if it was open slather, that there would be a shitload of people that would be trying everything under the sun to invalidate all the legislation that didn't work in their favour. So the judicial and policy approach is more saying, let's use this to see if we can illumine particular areas and then gain the information to then reform. So there's method to the madness. It's just frustrating to be on this side of the change.
Yeah, it's a good point, Amar, and there's been so much talk for decades about a federal Bill of Rights, but this is, in the absence of that Commonwealth-level human rights protection, the way states and territories do it is piecemeal and limited. But there are reasons, as Amar points out, why that is. The final thing I wanted to say about these acts is all of these acts are really the main remedy or action that's available to people making human rights complaints in these 3 states is it's an informal dispute resolution process. So in the ACT, Victoria and in Queensland, they've got in-house teams of conciliators that are a type of mediator, and basically when someone makes a complaint alleging a breach of human right, and that's allowed because it's attached to some other type of legal breach or alleged legal breach, then what the Human Rights Commission can do is organise a type of mediation between the representative of the government and the individual complainant, but it's not legally enforceable. It's just trying to enable both parties to come to some type of compromised position that they can live with. In the ACT, there is currently a bill before the Legislative Assembly which will add in the capacity to make a complaint in the ACT solely on the basis of an alleged breach of human rights, as opposed to it needing to be tacked onto something else. That will be the future, I suppose, for most states and territories across Australia, but it's a long road ahead. And I guess if you're going to take one thing away from what I've said, just in wrapping up, there is protection internationally. There's problems with enforcing that domestically, and even when it's enforced internationally, it's really up to the government. It's up to them to be in good faith to actually make changes. And domestically, there are human rights protections, but how you can actually enforce them is very limited. And so what it doesn't provide you with is a legal case that you can take to court and say, my freedom of religion has been breached under the Victorian Charter. You just can't really do that at this state. So that's the human rights side of things. I'll now hand over to you, Amar, to start talking about the constitutional side of things.
Great, thanks, Manny. So, to kind of pop up to 30,000 feet again. So what we're here looking at, and the question we were kind of looking at in that chapter that we were asked to write, was around whether there is a defence or way of kind of cutting through the current legislation around prohibited substances. Freedom of religion being one. So for certain people thinking or using the ingestion of entheogenic compounds, that there is an element of sanctity, and it is a religious type experience. So really what we're looking at now is jumping into whether or not, or what's the state of play. So if we're going to look to where the sources are of freedom of religion information, well, we've got these three sources that are up on the screen. International treaties, which Manny spoke to, then the State and Territory Human Rights Acts, and now we've got the Constitution, which we'll unpack a little here. So the notion of freedom of religion in Australia is quite limited, I'll say that, and I'll also say from the outset, there's been no successful claim yet made under Section 116 of the Constitution, which is a section that deals with freedom of religion. And I'll explain why that's the case. And that doesn't mean that there never will be. It just means that it hasn't happened yet, or no one's been able to kind of thread their way through the minefield. One reason that there's a narrow interpretation of rights is there's very few explicit rights written into the Australian Constitution. And this is because it was never its intended purpose. It was more fear around turning Australia into a single nation state, because each of the colonies, separate colonies, were on Australia, and the idea of them surrendering some of their autonomy was problematic at the time. So the purpose of the Constitution was really to allocate power between state and territory. And just to finish that point, the way the Constitution is written is and because of this fear of the states, it's that only the areas of law that are explicitly listed in the Constitution fall under the purview of the Commonwealth. Everything else reverts to the states. So that's the actual wording there of Section 116 that's up now, that deals with freedom of religion. So by virtue of appearing in the Commonwealth Constitution, this section only applies to Commonwealth legislation. It also has been interpreted in a way where the law has to be explicitly framed to limit religious freedom. So the way that the way the courts have read this to narrow the scope of it is to say, if this law has the effect of limiting your religious freedom, well, that's not really sufficient. So, if we were then to apply this to the current conversation, which is saying, well, the current situation of scheduling adversely impacts my freedom of religion, that's not the purpose of that suite of legislation. It's to, there's other arguments that they could make, from public safety, et cetera, et cetera, et cetera. So already we've got a categorical challenge to overcome, which is the purpose of Section 116 in the Constitution. In terms of that section, so if I just go back there, so the key words that we really need to tease out if we were going to look at making a legal argument or exploring some of the legal landscape around freedom of religion, the key words are the way religion is defined, and the question that then comes from that I've written up there, which is, the question is, can entheogenic usage be classified as a religion under Australian law? Then the word prohibit. So, can we interpret the prohibition on the impact of, or the scale or the scope of impacting your freedom of religion to include consuming any kind of compound? And lastly, is the scope of protection, the free exercise of religion, does it mean, well, you can do what you want, or does it just mean you can believe what you want? So does it cover beliefs and conduct, or one or the other, or what's the scope? So they're kind of the three big questions we'd need to address. So to deal with the first one, which is, could it be classified as a religion? So from the get-go, the term religion has to be applied in a way, so it has to be a religion that would be recognised under Australian law. The question, or the case where that's being considered, is just called the Scientology case. And it's in that there were different judgments. So this was a full bench in the High Court, and we didn't get a unanimous decision. The effect of that is to say, or indicates that we don't have consensus among the judiciary, which means that it makes the landscape a little more challenging because there's different ways of reasoning that have been applied. So the other thing I'll say about that is when there are split decisions, it's also, the judges know the personalities of the people who have written judgments. So it's not that just because it's a judgment, all judgments are considered equal. There's a lot of personality and values for the person that wrote the judgment that current judges are aware of, just by virtue of how much exposure they've had to it. So at the time in that Scientology case, the Chief Justice was Mason. Chief Justice Mason and Justice Brennan identified 3 limbs, and they had, so to be classified as a religion, you need to believe in a supernatural being. So again, I want to ground this in this conversation that this would indicate the need for a really specific sense of why you're taking this compound and how you see the world. So it's not just for exploration, it's that there has to be a supernatural being involved. The second limb that they posited was that there was an acceptance of canons of conduct to give effect to the belief. So again, depending on how it's framed, that may be problematic, because there's not necessarily one accepted way of doing or consuming entheogenic compounds. There's a bunch of different ways that people do it. So in order to make that argument, we'd have to talk about there being accepted canons. If we were going to make an argument saying, well, using this kind of boat to cross the river, these are how we're going to meet or how we're going to illustrate that we make the threshold. The third point that they raised is, instead of there being lots of criteria, let's just look at the sincerity of the adherence. Whilst it may seem like that's a really good thing for us, because we could say, well, if you're earnest or I'm earnest and we present our case, that's going to satisfy that limb. That's not necessarily the case at all. The notion of sincerity is really quite ambiguous, how that would need to be established, how this would be distinguished from recreational use. You know, there's myriad reasons why this would introduce a level of complexity into the conversation rather than give us what appears to be a really prima facie certainty. The second test, also written by 2 judges, talked about the empirical observation of accepted religions and pulling out certain attributes from there. And I think that's also, that's unhelpful and naive. What the hell is an empirical observation of a religion really about? You can engage in a sociological critique, but it's constructivist. It's a pretty old school, flawed way of looking at empirical thinking creating certainty. So I think, again, that's it's ambiguous, but it appeals to the way lawyers traditionally have thought. They also talked about the need for there to be insight into our relationship with our place in the universe. So again, I think when it comes to values of exploration or atheism and even being able to see if we could make a freedom of religion argument to support, no pun intended, a broad church, it's not really an easy case to make. Again, as I said with the previous test, this idea of a specified code of conduct doesn't really exist rigidly, or there's, depends, even if you go to tradition, where there's traditional ceremony, it's done differently in the jungle versus up in the mountains. How would you distill that, and how would you make this case that this is the way that it's would or could be applied in Australia? The third limb is arguably the most helpful for this community or someone in this community who wanted to run an argument, but it's also the most marginal judgment because we've got only one judge who went for this. what Murphy brought in, or Justice Murphy brought in, was looking at a really not a lot of categories, but saying what's the purpose of it? Why would you be taking it? And I think that would be much more interesting conversation for someone to be able to engage in that conversation. Again, picking up on maybe some of the traditional, shamanic or ethnobotanical ways of doing things, the reference to early occult, it can resemble earlier cults, but again, would you call shamanic cultures cultish? I don't know if that's really fair or appropriate, but that's the way the judgment was written. But it still does make that reference to historical ways of doing things, so there's something there. The third is, I think, really related to almost an integration of a psychedelic experience, which is it's not just being able to go, I've got a right to do it. It has to be done with an intention and in a cultural context where it's actually finding meaning and purpose in life. So, they're tricky and ambiguous. There's scope there on that third limb, but it's tricky. So that just deals with whether or not we could even classify entheogenic, compounds, sacramentally ingested, as a religion.
Just to add to that very briefly, maybe just quickly to tease out what we're talking about. Obviously, there's one judge that said that, and you would have seen it said minority judgment. In effect, a minority judgment by a High Court judge is not irrelevant for any other judge sitting under them in the Supreme Court, for example, but it's problematic, and in general practice, it's rare for judges to just choose a minority judgment and attach to that because it's easy to appeal. And what tends to happen often in practice is judges in lower courts will look at minority judgments for guidance, explication, interpretation aids, rather than saying that's the binding legal principle, because what's happened here is there's 5 judges, one judge has said this. So if a judge in the Supreme Court, for example, sticks to that, it's very easy to appeal and say, well, that's not necessarily determinative binding legal precedent you've attached to. It's actually just a minority judgment which you can take into account.
Yes, it's that kind of complexity that I think does lawyers no favour, or the whole rule of law. It does no favours because it seems impenetrable in its reasoning, and it seems on the face of it nonsensical. But there is consistency in reasoning. So just something to be aware of. I'm going to pick up the pace a little because I want to get through this. In terms of whether or not it can be prohibited, well, as I said, it's interpreted narrowly. That means it's not as Manny was saying in the human rights legislation, it's not a positive right to think and do what you want. The way 116 is written is to say there can't be legislation that explicitly interferes with it. The other reason, there's again the bigger kind of systemic reasons why this is the way that it's done, is judges aren't elected. And so when we look at the way the Australian democracy was set up, it was with what was called a separation of powers. So for the same reason that Manny said ministers signing treaties, so that's the executive branch, can't bind the legislature, is that they're different limbs of government. The judiciary is a third one. So the idea is that, and this kind of represents the thinking of the time, which is quite Newtonian, that you've got checks and balances, and if you have these 3 heads of government, then as a machine they're going to balance each other and keep each other accountable. The corollary of that is that judges are really reluctant then to strike down validly made legislation by saying, oh, it's not what the people want, because that's not what their job is. The judge's job is to determine whether something is lawful or unlawful with the way the law has been written, with the presumption that the government that people have elected are making laws that reflect the will of the people. So it'd have to be a really heinous act that the government does. The other point I'll just quickly say on that is there are lots of times where courts will also allow governments more authority. They'll widen the scope of power to solve problems. So declarations of war, or that's the significance of things like the declaration of pandemic, is that then courts go, okay, well, we're going to loosen this rigid hold on the legislature because they need to maintain, the word is peace, order and good government, whatever the hell that means. So that's something there that goes with, or hopefully will explain why the prohibition on laws just cutting through drug legislation to say we've got freedom of religion is difficult.
Just to add one very quick point to that, also all of this exists, we're talking here as lawyers and legal principles, but all of this exists within a political environment and a policy environment. And one piece of the puzzle which is important to keep in mind is really since the Keating years, there's been a kind of a culture in Canberra, irrespective of which party is in power, to often kind of try to sidestep the power of the High Court. It's happened, you might remember there was a judgment in relation to the legality of offshore detention, where the High Court made a ruling against the government. And so what they did was, rather than saying, you're meant to be the check and balance, cool, we'll have to really go back to the drawing board. Once the judgment was made, they just shifted the legislation slightly to try to get around it, going, well, this will buy us some time until someone else takes the matter back up to High Court to challenge it again. And so it's not, what it often requires is the government to actually act in good faith as well. And it's important because if the High Court found that a law prohibited freedom of religion, Parliament could just legislate an amendment also to just tweak the wording of that slightly until there's a new challenge.
Yep. So moving on to the notion of free exercise, you may recall, I said a little bit back that the question is whether the freedom of religion argument could cover both behaviour or conduct as well as your belief. So there's two precedent cases there. And the short answer is yes, it can. The key is that there has to be a real connection between the conduct and the belief, is what it comes down to. So, if we were to say that entheogenic or the sacramental ingestion of entheogenic compounds is essential, to having this kind of experience, then there could be a way of arguing this, presenting that argument. But there'd be a couple of other questions, which is, whether to make that argument, or is it the deification of the plant, which, certain people go for? Is it a deification of the compound? Where would synthetic compounds fit into that? Are these substances a bridge, kind of something that people use, but there's a wider ontology that it functions, or is it something else? So all of that would need to be really laid out very clearly. And as I said, no case yet has been run successfully arguing protection under Section 116. An example of this was a case where there was a Christian who said, some of my tax-paying dollars, when I pay my taxes, fund abortions. Abortions violate my religious beliefs. I'm deducting a portion of my taxes because I refuse to support that. And he attempted to use Section 116 to say, this should be protected conduct, my withholding of money. And the argument that was given was, no, there's not enough of a connection between your religious experience and the non-payment of taxes as an act. So, again, looking at the case law, there's some wiggle room there for someone to make an argument that could say that actually, the conduct of consuming a brew is very much directly related. So there is some wiggle room, but again, an argument needs to be made. And as Manny said, taking something up to a superior court is extremely expensive, and something that takes time as well. Other issues that need to be navigated is really that the composition of the judiciary in Australia in superior courts is not representative of cultural kind of plurality or modern ways of thinking. There's an over-representation of old white men who come from what are mostly Christian backgrounds. And so even though some of them may be really progressive thinking, there's all this encultured bias that they've picked up as a function of who they are, where they grew up, who their parents were. And then there's also the dockets that they've had previously to get to a superior court. There's years of working as a judge. There's lots of very difficult trials that they've seen. There's lots of horrible experiences they've had with violence, drugs, and addiction. Teasing this apart to even make an argument that entheogenic usage is a fundamentally different concept is not something that we can just presume. It needs to be really teased out and made plain in a way that makes sense to these people. There's a lot of talk in law about, before I referred to this empirical assessment of religion. Really, modern neuroscience shows, or cognitive neuroscience shows, that that's really a fiction anyway. Everyone subjectively constructs their worldview shaped by their history, their even epigenetic factors. These judges are no different, but they labour under the thinking that they're capable of objective thought. So I think there'll be generational shift to this as we see more diversity, as we see, the breakdown of silos. Like if we understand this in cognitive neuroscience, it's going to take time for this to trickle over into the way judges look and understand themselves and the way they think law. So the last notes on this really is just, it's not impossible, but it's highly improbable. We would need to see a matter run by a very, very wealthy benefactor who really was invested in making this freedom of religion argument. So it's not impossible, but it's difficult. Any successful claim, as I said, it'd need to be really well argued as well. We've hopefully kind of introduced some of the ambiguity that's there. And really the most effective pathway would be legislative reform. Remember, I spoke earlier about the doctrine of legislative supremacy. So if we can lobby for change, then the presumption of the courts will be that this is what is intended. So continuing the advocacy aspect is really what we want to do. So I think with that, is there anything, I've noticed you took some notes?
I just got a couple of questions directly from what you were saying. The first one is the case of Scientology. How does the UDV and Santodaimi fare in that? Because they seem to cover the three limbs that you were mentioning. So
yeah, well, they never presented those arguments, is what it comes down to. So, this is one of the ways that they really didn't get what I would classify as really quality legal advice before kind of trying to do what they do. I think that it's also very high level. Like I said, this would need to be litigated in a superior court and kind of following that pathway. So the essence so to bring it back, I think they could probably make a really good argument. They just haven't tried yet.
Cool. Yeah.
And sorry, if I could just add to that, they could make a good argument. The other thing that any group trying to litigate or bring an action to court would also have to really think a lot about, and I'm going to mention it in terms of legislative reform and public policy, is how to, since there are checks and balances and there aren't absolute rights, and Parliament can impose restrictions on the enjoyment of rights generally, for public safety, there would really need to be addressing that, starting to address some of the misconceptions about how this is a harmful substance and why it's not a harmful substance. The freedom of religion argument, in my opinion, will probably best be served by going hand in hand with other arguments to really overcome some of those counter arguments you might get from the other side.
Okay, and the other point that I wanted to ask was your mentioning of old white men and the generational change. Is the medicalization of entheogens going to help with that? Yeah, because it will show that there's actually a beneficial side to entheogens. It's not just drugs that cause a lot of the cases that end up in front of courts.
I would think it absolutely would. It's a relevant consideration on a similar matter. As Manny was saying, I think if all of these things create a Venn diagram, then we're off. I think that'd be strong footing.
And just to add to that, we're already seeing that shift across Australia, and we have been seeing for the decade the shift where Australia is becoming more and more progressive, albeit slowly, is in decriminalisation. There's probably a hesitancy to just liberalise everything, but the first step is usually decriminalisation. And so as the case and advocacy for the medical use of entheogens gets more and more support and some successful trials, then I suspect it would be furthering the decriminalisation side of things.
I want to specifically separate decriminalisation from medicalisation because I think most people here are very much in favour of decriminalisation, but the medicalisation can be problematic.
Yeah.
So.
Thank you, panel, for that enlightening and nuanced discussion.